Hello, everybody out there in IGF land. I'm Herb Lin. I'm the moderator of this debate on encryption. So I want to make some stage setting remarks for the problem, and then turn it over to our debaters. So my role is to be as neutral as I possibly can be in all of this. We have a crackerjack team of debaters, and you've seen all their bios already. Okay, so the resolution is that the government should require internet service providers and app providers to enable lawful access to data in transit that is protected by end-to-end encryption. So that's the statement that's being debated, and two people will support that proposition and two people will oppose it. So I want to set the stage by defining some terms. The government, we're talking about, in this context, I think, focusing primarily on the U.S. government, which is ostensibly a nation of laws with an independent judiciary, as contrasted perhaps to more authoritarian governments. The resolution uses the term lawful access, which means two things. That is, after going through all the appropriate legal steps, the government can obtain clear text for the for data in transit, that is, can understand what's being transmitted. And it also, just as importantly, means that without going through all those legal steps, if any one of them is omitted or done improperly, the government can't do that. Under those circumstances, the government is unable to obtain clear text. So both of those statements are important for understanding what lawful access is. The resolution refers to end-to-end encryption. In the standard definition of end-to-end encryption, the communicating parties have to establish the encrypted communications with themselves, and nobody else has access, and that includes the government. So the resolution has to be using the term end-to-end encryption in a way that's somewhat different from that. And the rest of the resolution, of course, provides a clue to that. ISPs and app developers necessarily have some role, and I expect that that part of this debate will address the nature and scope of that role. These observations, to me, implicate several issues, which I hope that the participants, the debaters, will address. First, should the confidentiality of data be in transit be guaranteed by technical means or procedural means? Those arguing for the resolution want the best possible protection against undesired and improper access, that is, access that is undesired by the parties to the communication, but except that requirement is subject to the boundary condition that it is possible for the government to gain access if and only if it complies with a lawful access process. So these parties have to be advocating for procedural protections assisted by technology to the extent possible. Those arguing against the resolution want the best possible protection against undesired access and want protection against all parties, including the government. These parties are advocating for technologically enforced protections that cannot be affected by procedural failures. I want the people in the audience to notice that these are different design problems. If you start with the first proposition, you'll design a system in one way. If you start with the second proposition, you design a system in a different way. Second, Attorney General Barr acknowledged publicly in a speech in July that the U.S. in 2019, that the U.S. government is indeed asking the public to accept a lower level of security and a higher degree of risk as the price for gaining the law enforcement benefits afforded by lawful access. In Barr's view, the increased risks of data compromise would be small, and the benefits to law enforcement and to the society would be large. Those arguing against that view would swap those adjectives, and the risks would be high and the benefits would be small. Are the risks large or small? Are the law enforcement benefits large or small? I want to point out that in a public debate such as this, those with insider access have security clearances have an advantage over those without it. So as such, it really is out of order for this debate to reference information that is not widely and publicly available. What's at issue is a policy question, and so the specifics of any particular incident aren't relevant because you can just make those up. I'm not accusing anybody that they would make them up. I believe in the honesty of everybody here, but you know, anybody can make up a bad scenario on either side of in support of their case, and policy has to be able to handle the extreme cases as well as the routine cases. Next point is that to ask is what's the limiting principle to govern either law enforcement access to encrypted communications or the extent and degree of security that's afforded by an encrypted service. In the absence of any limiting principle, stances tend to go to extremes. What user would not want the maximum possible security posture against undesired access? In the absence of any pressures in the other way, everybody would want the maximum, but maybe a countervailing pressure might be increased costs for greater security. Similarly, in the absence of a principle of limiting law enforcement requests for clear text, what law enforcement agency would refrain from making such requests? But maybe you could impose a budget hit or something for every request. Maybe that could limit requests to the most important ones. I hope that the participants will be able to talk about limiting principles too. And the last point I want to make is that in today's environment of political mistrust, how can the public be reassured that law enforcement requests for access to clear text are granted only subject to compliance with the approved procedures for gaining access? How can, for example, how can the public be protected against voluntary cooperation, in quotes, between ISP and app developers and the government? How can the public be reassured that law enforcement authorities will not bend or break established norms of behavior in response to political pressures? So those are my stage setting remarks. With those introductory comments, let's start the session. People should submit their questions as they arise, holding them rather than holding them for the Q&A period. The team, which does not include me, will notify the participants that submitted the questions that they'll be unmuted when the Q&A session comes around. And Rick Lane will be announcing the question asker. Dustin Luke will be controlling the mute and unmute and enforcing the time limit. I may follow up or go to the next audience question, depending on what I think of the answer. The participants, every participant in the debate agreed previously to the ordering of the speakers. They agreed to start out with a support, oppose, support, oppose sequencing. Then the debate will let it happen, and then at the end of it, it'll go the other way. It'll be the oppose goes first, support goes then oppose, then support. And with that, I will turn to the support side of this, which includes Stuart Baker and Darren Jones. So you guys, take it away.
Hey, thanks, Herb. Stuart and I talked, and I think I'll go first. Gosh, that's a lot of rules. I hope I can track on all those, but you give me a holler if I start to stray a little bit. Hey, I want to do three things really quickly here at the outset, but I'm really most anxious today, or most excited to kind of hear the questions and let the people drive this discussion. As I've talked more and more about this with folks over the last year, it's really interesting the questions we're getting back, and what I'm hearing a lot of people saying, wow, I didn't realize that. So I want to do three things really quick. First, I'll just quickly introduce myself. I'm an Executive Assistant Director for Science and Technology Branch over at the FBI. Amongst other things, I have within my purview the Intercept group that affects lawful access. within the FBI. And I've been working this, I've been an agent for over 20 years. I've been working this particular issue for well in excess of a decade. So seen a lot of change. All right, so with that, I want to do three quick things. First, I want to address the term that we hear every time this comes up. Every time it's debated, we hear this term, backdoor. Then I want to touch on the scope of this issue a little bit. And then finally, I want to touch on the kind of the marketing slogan out there that, hey, if it's not end-to-end, it's not good, or it's less than good. So let me begin by saying, look, we don't have time to get into a huge historical discussion about the etymological history of that term. I'll let you decide for yourself if it's appropriate or not. But I have to bring it up because of what it infers. And when you hear this term, and when industry says the FBI wants industry to give them a backdoor, what they're inferring is that law enforcement wants industry to build something and turn it over to them. Another iteration of this that you often hear is that law enforcement wants industry to produce some kind of a golden key that will afford them access to anything that they feel they need access to. And let me just say at the outset, absolutely nothing could be further from the truth. That's just not true. It's never been. What we do want is we want industry to design for themselves, to design, to implement, to secure, to operate for themselves lawful access capability. We don't want to dictate how this is done. We believe it's going to necessarily be very unique to different companies, to different platforms, to different devices. It could even be unique to different models. So there's no way that anybody can really dictate how that's being done. And quite frankly, we don't need to know how it's being done. All we need to know is when we have a lawful order and present that to the company, they can exercise their capability for themselves. I guess that's the other main point is we're not looking for direct access to anything. I'm certainly not looking for any new authorities. I don't want direct access to evidence. I want to be able to present a lawful order to a company and have that company be in total control of that capability and have them exercise that capability after they reviewed that warrant and then respond to that warrant appropriately. That's what we're asking for. We're not asking for industry to build something and then just say, hey, law enforcement, here you go, go crazy. Another thing, let me set the record straight. We're asking industry to create and maintain their own keys when it comes to these capabilities. Law enforcement does not want to hold the keys. That doesn't make any sense for a whole host of reasons, not the least of which is those keys are going to be unique to the products and services as well. So if you think about it, industry actually does this right now, okay? They maintain and control those keys today. They sign updates. They push those updates out to device. Look, I won't use the same term. I don't think it's an appropriate term in any way, shape, or form. Frankly, I think maybe a more appropriate term would be secure loading dock, if you will. It's where industry maintains that connectivity so they can push out signed, cryptographically signed code updates, and then they can pull back user data for marketing purposes. Hey, that's okay. There's nothing wrong with that business model. But make no mistake, companies are doing this quite effectively and quite securely today. So for companies to suggest, or people to suggest that this isn't possible, I just don't get that. We are doing it. It is being done in an extraordinarily secure manner today, and quite effective. Is it perfect? Of course not. But it's being done today. And what I mean by saying that, hey, that's not a bad business model. You know, these folks are making these decisions on behalf of their companies. They're doing what's best for their companies. Their fiduciary responsibility is to their company and their shareholders, but not to the American people. And so to make these decisions which have consequences for all of the American people, that's not a decision for the boardroom. That's a decision for the people through their representatives. Okay, so let me move on real quick to the next point, and that is that oftentimes people think, well, we hear the FBI talking about this, must be an FBI problem. Look, this is a global law enforcement problem. Okay, if you were paying attention last year, you probably saw the IACP, International Association of Chiefs of Police. All right, 31,000 law enforcement agencies from around the globe, 165 countries, issued one of the strongest resolutions I have ever seen that body issue, aggressively calling for worldwide legislation for lawful access to deal with this. And look, it's no secret, the FBI has legal attachés around the globe. I talk to those folks all the time. There is no rule of law country that I'm aware of that isn't struggling with this issue. So when I say this is just not an FBI or a Fed problem, this is a law enforcement problem. I also talked to the 18,000 law enforcement agencies across this country. I talked to some last week. One of them told me they think as many as 25% of their devices that they touch, they now can't get into. It either stops investigation or it impedes it in a significant way. And think about that, 18,000 law enforcement agencies. We're talking some pretty small agencies. One of the agencies I talked to last week had 9 people. I don't think they're going to be able to employ somebody that tries to hack devices or otherwise. They have to rely upon the law and what they can do under the law. So then the last thing I'd like to touch on real quickly is this false argument, if you will, that somehow, if it's not end-to-end encrypted, it's less than good, or it's substandard in some way. Let me give you a good example. And Herb, I hope I'm not going to far askew of your rules here. I'm going to use the intelligence community and my own office here as an example. Look, I'm sitting here in the FBI. I send text messages and emails around the globe every single day to intelligence community partners, to Five Eyes partners, to the legates in our embassies around the world. Highly sensitive information. None of that traffic, 0, is end-to-end encrypted. Now, to be absolutely sure, let me put your mind at rest. It's extraordinarily robustly encrypted, incredibly encrypted, but it's managed encryption. Just like the billions and billions of dollars of financial transactions that happen in this country every day. It's managed encryption. And think about digital rights management. If you can't have a managed encryption dealing with that, it's not going to work. So this argument that, hey, it's not end-to-end and therefore it's bad, look, that's just not true. So let me stop there. Can't tell you how excited I am to hear what folks have to say and answer the rest of the questions. I'll stop there, Herb.
Okay, thanks. Next up is the opposed side. Thank you, Darren.
All right, I drew the short straw between myself and Susan, so I'm going to go first. First off, sorry, Darren, I'm going to use the term backdoor today. It's 2 syllables long, and I have 6 minutes for my opening statement, so I am going to use that. 2 starting points. 1, law enforcement can still do its job even if it can't obtain access to all encrypted data through lawful process. Second, a backdoor is a security vulnerability. It can be found and exploited by the bad guys. It can be abused by the good guys. We don't yet know how to build one that is confined only to legitimate uses, only by good guys. And we've seen this problem play out with telephone networks in the past. So it should not be the policy of our or any other government to make average law-abiding people's data less secure than criminals' data. But that's what the resolution entails, because we can't put the crypto genie back in the bottle. The technology is out there. It's in open source tools. It's in products from foreign entities outside US jurisdiction. It's in tools that the bad guys create for themselves. Bad guys will always have access to unbackdoored encryption. Meanwhile, the majority of US users, and I'd say users around the world, are average law-abiding people, and most of them aren't going to go to the trouble of seeking out unbackdoored alternatives to major mainstream services. I think it's a bad trade-off to weaken all users' security in order to give investigators an easier time pursuing the fraction of users who are criminals and don't bother to switch to other tools. Moreover, investigators now have access to an unprecedented array of sources of evidence, but they are not using that access efficiently. A 2018 survey of US law enforcement agencies revealed that the biggest problem that they currently face in leveraging digital evidence is not encryption. It's accessing the data that's held by service providers, much of which still is not encrypted. Today's resolution is not responsive to the main challenges that law enforcement themselves have said that they actually face. Plus, government officials, lawmakers, America's warfighters, everybody uses the same commercial off-the-shelf apps and services as everybody else. Mandating an access mechanism in those services will place their data at risk too. We just saw this risk illustrated in the hack of the Twitter accounts last week of high-profile people, including the presumptive Democratic nominee for president, Joe Biden. I don't need to make up any scenarios. This actually just happened. The details are not yet clear, but what we think we know is that the hackers may have downloaded the direct messages of some accounts, luckily not Biden's, and they may have gained access by socially engineering Twitter employees. Employees can be duped, they can be bought off or extorted, or they can be malicious actors themselves. Don't forget, last year, other Twitter employees were criminally charged for spying on users on behalf of the Saudi Arabian government. Today, Twitter direct messages still aren't end-to-end encrypted. Insider threat risk is one of the reasons why other tech companies have embraced end-to-end encryption in recent years. They realize that they need to include themselves in their users' threat model. If the Twitter hack really just was a stupid cryptocurrency scam, which is what it's looking like, then we really dodged a bullet. As former DOJ and Defense Department lawyer Jack Goldsmith has observed, US society is uniquely heavily digitized, and that creates asymmetric vulnerabilities that foreign adversaries can exploit by everything from cyber espionage and cyber theft to ransomware attacks. Today's resolution would exacerbate those vulnerabilities, and it would be a gift to our adversaries. It would also harm US economic interests. Overseas customers don't want services they know have a US government backdoor. The 2013 Snowden disclosures damaged trust in US businesses so severely that it's still being felt now in last week's Schrems II decision by a high court in the European Union, which struck down the legal framework for transferring personal data from the EU to the US that many US businesses relied upon. Australia is also a cautionary tale. Its tech sector has taken a major hit since the passage of a 2018 law reminiscent of today's resolution. The other economic impact is the cost of data breaches, hacks, identity theft, industrial espionage, IP theft, and other losses foreseeable from forcing systems to be less secure. It is for all of those reasons that CALEA, the 1996 US federal law requiring phone networks to be wiretappable, preserves telco carriers' legal right to encrypt calls and throw away the decryption key. Congress realized then the importance of secure communications, and it's all the more crucial today. That's why so many of America's former top intelligence, defense, and law enforcement officials have vociferously opposed encryption backdoors. Focusing only on law enforcement goals shortchanges other compelling interests, from individual privacy to national security to the economy, and finally public safety, the usual justification for increasing law enforcement surveillance powers. But public safety does not just mean investigating crime after the fact, and what's more, law enforcement does not have a monopoly on public safety, and law enforcement agents aren't always the good guys. Public safety also means preventing crime from happening in the first place, and that's what encryption does. For example, encryption helps domestic violence victims to secure their data from their abusers. However, domestic violence is 2 to 4 times more common among the families of police officers than American families in general. Backdoors for police are backdoors for abusers. Police violence is the other deadly pandemic in our country. 1/3 of all Americans killed by strangers are killed by the police. Recent peaceful protests against police violence have been met with more police violence. In Portland, unidentified DHS agents have been kidnapping protesters off the street and tear gassing and beating mothers and veterans. Earlier this week, DHS gave itself the power to conduct domestic surveillance of protesters, regardless of whether they're on federal property, something former DHS official Paul Rosenzweig calls a complete misapplication of existing authorities. The DHS grabbing power and turning an American city into El Salvador shows why individuals like you and me need strong encryption to protect our constitutionally guaranteed rights of privacy, speech, assembly, petition, and due process. It also shows that the government cannot be trusted not to abuse any power it gets. So whenever one of us panelists says the words law enforcement, the audience may wish to picture the roving DHS squads in Portland. I'll hand the time over back to the for side now. Thanks.
Okay, thanks, Rihanna. Next up, I guess, is Stuart. So onward, Stuart.
It appears that we may have lost Stuart.
I hate technology. That's not that's not a biased comment. All right. Well, let's wait until Stuart gets back. And Darren, do you want to say something in the meantime?
I suppose I can use up kind of the 2-minute rebuttal thing at the end if you want me to take a few of those minutes now.
Sure. Why don't you do that?
Okay.
I guess we're going to have to improvise here.
I would a couple of the things that I'd like to address. Rand raises some good points, and one of the points she raises is that of overarching cybersecurity. look, I can't speak obviously to the Twitter matter, very much ongoing. But what I can tell you is I think that's indicative of many of these cases. Is typically it's not the technology itself that's driving this. It's the application of the overarching cybersecurity that's causing some of these problems. And typically, again, it's the human being who is the weak link in that chain, who is having the issue. So one of the things I would say, though, in cybersecurity is look, things like end-to-end encryption cut both ways. I mean, think in a very simplistic form, what that is that's an encrypted tunnel. It's encrypted such that nobody can see into that. So, when I try to decide what service I'm going to use, what email provider I'm going to use, one of the things I kind of like about some of the services, I'm not going to tell you who I choose, but is the fact that by definition, it's absolutely not end-to-end. Now, it uses very robust TLS encryption. But one of the reasons I like it is every once in a while, a couple times a year maybe, I get a notification saying, hey, the system screened malware off your incoming email. Somebody was trying to send you malware to compromise your device. We caught it in the filters. We screened it out for you. Hey, look, I'm a tech guy, and I like to think I keep my stuff up to date. But if I'm in an direct end-to-end relationship with you and you try to send me malware, I better be on my A game, because there's nobody between you and I. All of that risk, all of that work that is being done traditionally in cybersecurity now by some of these larger, extraordinarily successful and efficacious companies and systems is now being shifted down to the end user if you do that. So there's a trade-off there, and you're starting to hear that from the actual cybersecurity community and even the financial community is, look, we're not just going to let this encrypted traffic go in and out without somebody looking at it. So it carries with that risk. And what I would say overarching in cybersecurity, there is no perfect solution. But well-managed encryption is as secure as end-to-end encryption. It depends on the application, how you're applying it, and how it applies in the overarching piece. Since Stuart's not on, I don't know if that was 2 minutes or not. I'll cover one more issue, and that is, Rihanna brought up constitutional protections. I'll tell you, the mission of the FBI is to protect the American people and uphold the Constitution. So think about that for a sec. Let's think about the Fourth Amendment. Even our founding fathers 200 years ago realized there were going to be times when an individual's privacy was superseded by the greater public good. And they put that into the Fourth Amendment, and it spells it out, and it goes on to spell out exactly what is required then. What protections do we put in place to make sure that law enforcement doesn't overstep? And it talks about having to get a warrant. That's exactly what we're doing. We want to do the exact same thing now as we have been doing for years. 4 or 5 years ago, companies, we present the warrant, and they answered it. Over the last several years, companies have decided, look, I'm implementing technology in such a way I can no longer respond to your warrant. I'm going to make that decision independently. And now I can say I just can't respond to that warrant. So what I would say is, look, I'm not good with the company setting aside 200 years of a system that we've had in place. It works rather well, I believe. So if the Congress decides it wants to make a change, I will salute and do whatever the Congress says we're going to do. But I'm not, as a citizen or otherwise, I didn't elect anybody in Silicon Valley. And so for somebody making those decisions in the boardroom, I'm not good with that, especially from a law enforcement perspective. I've got to deal with the victims, and I've got to deal with trying to prevent these things. So I think I'm kind of encroached on my 2 minutes.
Okay, but Stuart still hasn't shown up. So would one of the anti side like to respond to Darren's comment that managed encryption is just as good as end-to-end encryption?
Sure. Do I take 6 minutes now? Do I take 1 minute?
I take 1 minute and let's see what happens here.
Sure. So we have numerous examples where managed encryption doesn't work so well. And one that jumps to mind, because they're an organization that really cares about security, was Google and the Kalia implementation, And of course, they were hit by a nation state attack where the interest was, who was it that was subject to wiretap orders from the US government? Why did the Chinese want to know that? Because they wanted to know which of their agents were compromised. So managed encryption, key escrowed encryption, works fine unless you've got a strong adversary, and then it doesn't, as we know. And I'll stop there for now.
Well, okay, so we still haven't had. I'm going to have to improvise here. With apologies to everybody. I was hoping that Stu would be able to be on here. Susan, why don't you take your 6 minutes now? Maybe it's 5 minutes now. Take your 6 minutes now, and then I'll give it back to Dustin to simulate Stu as best as he can.
Okay, so I don't think anybody can simulate Stu.
I understand.
I'm going to start by saying to Darren that one of my friends from the NSA once told me that a warrant may give us the legal ability to go after content, but it doesn't say that it should be easy. And that's how NSA approached it. You mentioned that it's not a backdoor, a golden key. What do you call it? I mean, it's all the same thing. But when you come to the approach of design it yourself, I'm reminded of something my colleague and co-author has said, Matt Blaze. He said, sure, we can design something to land on the sun, but can we get the person back afterwards? It's very easy to say, oh, Silicon Valley is full of smart people, but designing a secure system that can withstand nation-state attacks is a very different thing. You said, well, we do update keys. Update keys are pretty different. Somebody steals an update key, they first have to reverse engineer the system in order to change it. They can't use it immediately. And then changing the system to accomplish what they want works only as long as there isn't a new update that will change the system in a different way and cause their update key to be less useful. So using the analogy of update keys is something that might convince people who are not technically apt in Washington and Brussels and elsewhere. But for anybody who knows technology, the two systems are not the same. And that's been written about by the tech community. And you mentioned that some people would want the government to have access. Any of those people can use a key escrow system. I'm not surprised that law enforcement, 31,000 law enforcement agencies want this. When I testified in Congress in 2011, the president of the International Chiefs of Police was there. At the time, he wasn't dealing with encryption, but he said they had multiple phones with multiple operating systems and they couldn't open them because there were too many operating systems. It's true that local law enforcement, in the United States, we have 18,000 different law enforcement agencies between federal, state, local, and tribal. So it's of course true that many law enforcement agencies can't open systems, but they couldn't open them before encryption either. And then you ask, well, let me move on. This problem, of course, has been around since the late 1980s when the NSA went to the FBI to warn the FBI of the problem. It's been over 30 years, and while the NSA adopted to the availability of strong encryption internationally, and in fact went along with the U.S. with the executive branch and said, let's change the laws on the regulations on export controls back in 2000, the FBI has for 30 years said, help, help, it's too hard a problem. In fact, in 2012, when the FBI had on its web pages, password protect your phones, which is, of course, the right way to secure devices, in 2014, they removed that information from the website, which is, of course, the wrong way to go. The fundamental reason that the resolution should be voted down is because it doesn't make sense. We know that for a variety of reasons. One, of course, is that it destroys forward secrecy. It destroys the ability to do forward secrecy, which means that you change the encryption key with each message or each set of messages. That, of course, is a strong form of encryption. It prevents the kind of thing that happened post the Second World War, when the US was able to decrypt a vast amount of Soviet messages, good for the US, but had the tables been turned the other way, it would not be so good, whether it's for the US government or United Airlines or General Motors or any American company. National security people agree with that point of view. You had in 2015 an op-ed by McConnell, Chertoff, and Lynn. Lynn was Deputy Secretary of Defense, saying end-to-end encryption is critical. General Michael Hayden, former NSA director and CIA director, said protect phones and devices. Robert Hannigan from GCHQ said end-to-end encryption. Former director of GCHQ said end-to-end encryption is crucial. And Jim Baker, former general counsel of the FBI, came out last fall and argued in favor of strong end-to-end encryption. Well, not just the problems with forward secrecy and authenticated encryption, but the threats we now face, which include Huawei, and the fact that communications infrastructure is insecure. So what I would suggest that the FBI and law enforcement do is turn to solutions like what has been in the CSIS study on looking at small, low-hanging fruit. There's been a real lack of analytical capability. So while the FBI has a number of very strong people, it doesn't have anywhere near enough. State and local, as you observed, don't. So there's a lack of analytical tools. There's a lack of information sharing. There's a lack of training. All of these problems were pointed out in the CSIS study. They've been pointed out for years already. Those are the solutions. I was at a meeting in 2016 with a senior member of the FBI who said, what do we do with the metadata? The communications information, the communications metadata comes from the carriers all in different formats. It's too hard to deal with. That's the sort of thing that my undergraduates could handle. It's an easy problem. We shouldn't be hearing those kinds of arguments from law enforcement as a reason to do away with end-to-end encryption. And I would urge you to look at both the National Academy study from several years ago and also the study from the Carnegie Endowment, which the Carnegie Endowment came out with a report last fall, that said, look, throw away the straw man that you can never look at the idea that of weakening encryption or will have no security, and also throw away the idea that law enforcement can't do its job unless it can get access to every encrypted message. Throw those out. What problems can you solve? And we did a very careful analysis. The people on the committee included not just people from civil society and not just people from the computer industry, but it included the former deputy director of the NSA, a former deputy director of the CIA, a former Homeland Security advisor to the president, and a former general counsel of the FBI. And we said, let's leave alone the issue of end-to-end encryption because of the technical problems and because law enforcement has been arguing for a long time that the problem is devices. Let's look at the issue of devices and let's look at the issue of phones. And let's see whether or not there's a technical solution. Before you go to law, let's first look at whether or not there's a technical solution. And if there is a technical solution that leaves the country with sufficient security despite the kinds of national security threats we faced, if there is a technical solution, let's look at the possibility of law and regulation, but not the other way around. And so I would urge you to go that direction. Thank you.
Okay, thank you, Susan. And we have Stu Baker back. So unfortunately, we're going to have to change the agreed upon order. So Stuart, you're on. Stu, you there?
You're on mute.
Okay, I am off mute, I hope. I apologize. We had a storm in Washington that knocked out my internet. So while I have the cleanup position, I have the disadvantage of not having heard half of Rihanna's and half of Susan's remarks. So I'll try to address the arguments that I heard them put forward or that I expected them to make. I start from the proposition that we have a set of companies whose worth is $1 trillion in some cases, who have massive profits, saying, "Oh, well, we can't solve that problem. That's impossible. Giving access to secure communications can't be done." An implausible position, and one we wouldn't tolerate from any other industry. If the automobile industry had said, "Oh, airbags? Oh, you must be kidding," and they'd probably blow up in people's faces, and it would be awful. You don't even want to go there. And take lead out of gasoline, the cars won't run as well. There are terrible consequences to all this, and we can't solve them. We would have said, as we did say, you find a way to solve it, and we'll evaluate whether we're unhappy with the result. And
I'm not sure if I should just automatically pick up and carry on.
Yeah, I think we got to do that.
So, okay, so a couple things I would say to Susan is look, I've got an awful lot of talented people here in the Bureau. I've got buildings full of very, very smart people and lots of very expensive equipment. And I have the luxury of being able to engage in a very open way with partners inside the community and around the globe. And what I'm telling you is, this is still a problem for us. This isn't a low-hanging fruit issue. I mean, law enforcement, we can always do better in training, and we can always help law enforcement agencies, especially some of the smaller law enforcement agencies who don't have the resources, up their game to be more efficient and do some more things for themselves. But what I'm saying is, it took me 4.5 months to get into those phones in Pensacola, all right? And I'm here to tell you, the director told me in no uncertain terms, I can do anything. I can spend any amount of money. I can apply any resource. I can do anything, including asking one of these companies for help. The response was no. So applying every resource I can, and we got a lot of people that we talk to inside and outside the Bureau in the community. 4.5 months. So you remember Sutherland Springs, right? 26 Americans dead. I'm still not into that phone. Okay, this isn't a, well, gosh, you just need to work harder problem. And I got to tell you, all the money in the world throwing at this problem isn't going to solve this problem. This is an issue of companies making an independent decision to apply technology in such a way that it independently precludes law enforcement from accessing this data. It's a fundamental question we have to ask ourselves as an American, or as Americans. I mean, it's a trade-off. You're absolutely right. Both of you touched on it. It is absolutely that. It is a balancing act that we have to do in this country, and we have to decide what is the risk that we're willing to take in our cybersecurity and in our real world. And, you know, a lot of times what I'll hear is, look, the companies have other ways they can do this to help us. They'll do this artificial intelligence. It's going to work for us. So I got to say, I am not convinced there yet either. You know, at the front of the COVID thing, we saw Facebook having to limit the times they forwarded WhatsApp messages. That's already ended encrypted. So if the AI stuff is working well, I'm not sure why you would have to go to that extreme. The other thing I would suggest is, so we haven't talked about the whole NCMEC and the kids thing. You know, a lot of times what I hear from industry is, you know, those numbers are inflated. There's a lot of duplicates in there, 16, 17 million, whatever it is. That number's not right. And what I always say is, okay, let's be very conservative. Let's cut that number in half. Let's say it's 10 million. Then let's cut that number in half again. Let's say it's 5 million. If you end-to-end encrypt what they're sending over to NCMEC now, even if the AI does work, they're going to send something over to law enforcement that says, hey, the algorithm suggests that this guy's doing something bad to a child. You should do something about it. How many of those kids, I mean, at what point as a society do we determine that this issue is worth doing what we're doing. You know, you talked about it's not apples to apples when you talk about these phone updates. I get what you're saying. It's not a perfect analogy, but what I was saying is even doing an update presents a little bit of a security risk. But the mitigation that you get in doing that update offsets, in most cases, the risk of having to go into that device and do the update. So it's not a perfect trade-off. There's never going to be a 100% solution on either side of this. I don't have that in Kalia today. But to suggest that somehow this is impossible, and you name so many people, I'll be honest, I can't keep track. But you remember a couple years ago, they asked Bill Gates, what do you think? And let me read you the quote. The companies need to be careful that they're not advocating things that would prevent government from being able to, under appropriate review, perform the type of functions that we've come to count on. And when they asked him, are you talking about unlocking iPhones? What he said was, there is no question of ability. It's a question of willingness. And when they asked Butler Lampson, the Turing Award winner, which is the Nobel Prize for Computer Science, there is no higher award. What do you think about this? What did he say? He says, the idea that there's no way to engineer a secure way of access is ridiculous. So I would echo what Stuart said before. Look, to simply say this is impossible, I can't buy that. Let me, even though Stuart's not back on, let me hush up and you guys can respond.
Well, okay.
At what point do we go to questions?
Dustin?
Are you ready for the Q&A from the audience?
Yes, I think that we should go to the Q&A. I have lots of questions, but I'm sure that you have lots of questions too from the audience, and they should get priority. Okay,
great. So just based on the fact that we're a little bit behind and off track and have had enough technical difficulties, we're just going to have Rick as the Q&A moderator read off the questions here.
Hey, just for the record, Stuart was using end-to-end.
Go ahead, Rick.
We'll start out with the first question. And can you hear me okay? Perfect. Question from Bill Juris. How do we provide lawful access for governments which follow the rule of law while protecting users who are subject to governments which do not?
It's really easy. You have a bit in the algorithm. It's called the evil bit. And you turn it on for the evil governments and off for the good governments. I mean, of course, I'm being sarcastic here. The answer is you can't, and that's one of the many problems.
So let me, if I could, offer an alternative view. I think it is true that you can't protect people from their own government, from the United States. And we can't protect the Chinese today from their government's access to their communications. Governments that want access today are going to get access today. We don't make the rules. This is not the 1990s where we say, do it our way or don't do it at all. Every government is going to make this decision themselves. A lot of democratic governments are coming very close to mandating lawful access already. So what we decide not to do will not have any impact. It's as though we had said, gee, privacy law is too hard, it's too complicated, don't regulate. In fact, that's what we did say. And the rest of the world said, yeah, screw you. We're going to write our own regulations. They may not be very good. We may not like them in the United States, but that's what they've all done. And that's what's going to happen here. Our decision not to do this just means that we have decided that our law enforcement won't have access to this. And one last point on this. It's not as though the current system that we have is good for people in authoritarian states. What's the current system we have? When the FBI really needs access to something, they go out and spend $1 million. They buy a vulnerability from some third party, maybe not even in the United States, and they apply it to the Apple phone that they need to get into. And in the process, they are underwriting the entire industry that provides vulnerabilities to governments so that they can get into phones. We are already subsidizing authoritarian governments who want to get into the phones of their citizens by creating this market for vulnerabilities to be used for law enforcement purposes. So the evil things that Susan says are going to happen as a result of this are happening right now, and it's partly on us.
And let me distill that down to one sentence for my part is, are these companies seriously asking me to increase the risk to Americans just so the company can do business in some of these countries, to assuage that somehow calculation? No, I hope not.
So I've got to answer this one, which is that by trying to undermine end-to-end encryption, which is the only way we know of really securing a communication, by trying to undermine end-to-end encryption, what we're doing is creating what we would be doing is creating a massive security problem. And that's why you had all the security people that I mentioned, and many more, national security leaders, speak in favor of end-to-end encryption. I noticed you mentioned Bill Gates, who isn't a security guy, and Butler Lampson, whom I love quite a lot, but who has not actually built such a system. And we all know that the mathematics in crypto systems is usually good. The protocol sometimes has flaws. The implementations, as Butler knows, inevitably have problems. And here you would be talking about a massive security risk.
I have to intervene here on both sides of this. This is just another example of how both sides are talking about different system design problems. Is it possible to make an airplane that's made out of lead? Sure. You could, and it would sort of fly, okay? But we don't do that for a variety of reasons. That's the kind of problem that that's what the pro guys are trying to say we can do. And sure, you can make a secure system subject to the requirement that law enforcement get access, but as Bill Barr says, that increases the risk of improperly accessed communications. He says that risk is small and the benefits are large. What Susan is saying is that the benefits are small and the risks of that are large. And so she wants a system that doesn't have access by anybody at all, except to the participants on either end. You're talking about different systems with different...
No, Herb. I'll go back to what I said about a half hour ago and the Carnegie report, which said, start with the problem that law enforcement says it's most interested in, not the one we're debating today, although I noticed that Darren brought it up earlier, munging the two together. But the Carnegie report said, start with the system that law enforcement has been arguing since San Bernardino, or even a few months before San Bernardino, is most important, which is locked devices. See if you can come up with a solution. If you can come up with a solution, a technical solution that seems sufficiently robust, then think about laws. Then move to end-to-end, which is fraught with many more problems. So I didn't argue never. I argued make it secure.
So while we're beating up the moderator, let me join in beating up the moderator. There is no perfectly designed end-to-end system that provides security. There are access features built into our phones. They're called updates, by which Apple sends us arbitrary code that we cannot stop from operating on our phones. We have to trust them, and they have to make sure that they have secured their update system in a very careful procedural way. But they have built a backdoor into their phone, and they think that the back door is worth it because it enables a lot of security updates. And they would say, when you balance out the risk of security failures is worse than the risk that somebody's going to compromise our update feature. I think that's probably right. And all we're really saying is, well, when you do that risk analysis, why don't you ask what are the social consequences of having perfect encryption that the crooks can rely on all those costs, versus the cost of actually having a lawful access feature that is surrounded by the kinds of procedural protections that you have for your update features. And there are dozens of others. We have end-to-end encryption on Zoom in theory, but we don't. Why don't we have it? Because the people who wanted to phone into this conversation wouldn't be in it if Zoom had true end-to-end encryption. And Zoom decided that the costs and the risks of not letting those people in was worse than the risk of not having perfect end-to-end encryption. We make those compromises in the real world all the time. It is only when we ask for access for law enforcement that suddenly the mathematicians tell us it's impossible.
I don't think they're saying that it's they're saying that certain requirements are impossible to meet. But in any case, let's move on here. Dustin, or Rick, do the next one.
Sure. This is from Gregory. How is the law enforcement proposal reconcilable with Article 12 of the Universal Declaration of Human Rights? No one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence.
I'll take that one. And the answer is lawful access under a search warrant, access under legal procedure. And I've not heard FBI argue against that, although we do have a history, which Rihanna went through partially, of times when things have been unlawfully done. But the answer to the Article 12 issue is you only access under an authorized warrant. And of course, some nations have a much more robust system of warrants than others.
And I'll sort of add onto that. I think with regard to the UDHR language like it, we're going to see that question be answered more definitively by other countries before we see an answer here in the United States, where we tend to think and talk within a Fourth Amendment framework. India, for example, has recognized a fundamental right to privacy for the billion people that live there, including quite a lot of number of WhatsApp users, as it happens. They are currently confronting whether to implement guidelines that would demand traceability of messages, which as a necessity would require knowing who sent what message and therefore being able to read the content of messages. It remains to be seen whether their Supreme Court will decide that that is consonant with the Supreme Court's more recent decision saying there is a fundamental right to privacy for everybody who lives in India. Likewise, Brazil is confronted with some similar questions with respect to whether WhatsApp, which also has a lot of Brazilian users, can be compelled to change their encryption in order to respond to wiretaps, an issue which has come up here in the United States as well. And we know from, even though these cases are still pending, some of the justices have strongly indicated that because there is a fundamental right to privacy that is recognized in the Brazilian constitution, that means that companies cannot be required to change their encryption in order to enable access, because that would be an invasion of this fundamental privacy right. We've been talking about GDPR, et cetera. I think we're going to see these kinds of questions teed up and answered outside of the United States before we see it addressed here.
There is no country that believes that the right to privacy can never be intruded upon where law enforcement needs require and where the justification has been presented to a court and the court has approved it. This is a brand new idea that people should have an absolute right to privacy simply by installing particular software on their machine.
Yeah,
I had the right to privacy before there were any kinds of machines. You know, I had a right to privacy to speak privately with somebody in the corner, you know, in hushed tones behind a hand so nobody sees what I'm saying. And if we're going to say that the Fourth Amendment permissiveness for warrants or for a legal process means that there cannot be any spaces that cannot be intruded upon by the outside with the proper type of paperwork in hand, that means that I would no longer be allowed to have those same quiet conversations. It means that there would have to be some means of recording those as well, and that is never what the Fourth Amendment has meant, and it's never what the right to privacy has meant.
But
so the government has always been able to install bugs or have eavesdroppers listen to conversations, even when you thought they were private. No one thought, and I don't think anyone believes, that we need to find a technical solution for people hiding out in the woods having conversations. But WhatsApp enables you to have 1,000 people in the woods stocking up arms and making plans for an attack. And that's never been something that people could have gotten away with in the old days that we're imagining.
And let me follow on that one thread, Brownie, that you brought up on the First Amendment. I think everybody, all Americans, I hope, feel like we have that fundamental right to privacy. And we certainly all agree, I hope again, that we have that fundamental First Amendment right to freedom of speech. But that's a great point. That fundamental right to freedom of speech is not absolute. You don't have the right to say absolutely anything, anytime you want, in any way you want. You can't put other people at risk. This is not a country of absolutes. And so actually for a sec there, I thought I was going to take extra credit because Susan and I had a point where we could say we agree on the warrant.
Yeah.
I guess my next step would be, okay, but after I've done that, after I've followed the Constitution and the Fourth Amendment and federal law and gone to the judge and the judge has fully adjudicated those privacy interests, how is it that one man or one company or one entity can simply set that aside and say, look, I'm going to apply technology in such a way to simply set that aside. I'm just doing exactly that. I'm going to decide that that doesn't apply through the application of technology. And as an American, I'm just not good with that. And as the guy that has to deal with the victims, and the other point, Susan, that you made before where you said, look, you should deal with this. Look, I met with the Carnegie folks and I hear what you're saying. It is difficult. It is more difficult. But frankly, I don't have the luxury in my job. Nowhere in my job description does it say, you only have to worry about the easier threats. I have to worry about all of the threats. And so I can't just say, you know what, we'll cover this one when it gets less hard. It is what it is. We have to address this from a law enforcement perspective. People are getting hurt. And our job is to stop and to prevent that and hold those people who do it accountable. And this is really, really having a detrimental effect on that effort.
Next question.
Well, I think we are getting close to running out of time, and we wanted to get to some closing arguments. But there was a question about the recent legislation by Blackburn and Graham dealing with encryption. And so I don't know if folks have thoughts on any legislation that's moving through Congress and they want to include that in their closing remarks.
Okay, for closing remarks, given the technical glitch that we experienced at the beginning, which shuffled the order of people, in the interest of fairness, I'm going to shuffle the ending as well. For opening, an opposing party will start, and then both the supporters will chime in, and then the closing, the last person will be an oppose. So,
Darren, I'll go. So let me go back.
It's Deanna first, then one of the two of you.
Oh, sorry.
Yeah, sure, no problem. Thank you for the conversation today. I think we are all sort of used to having these same discussions, and I hope it's just been beneficial for the audience, which may not be as used to the same discussion as the group of us are. I just want to go back to something that Darren had said about companies making a unilateral decision all on their own, and that Darren would prefer to listen to the will of Congress. Congress is the one that authorized companies to make those decisions. I mentioned the CALEA statute way back at the start of my opening remarks. CALEA is exactly what enables companies to choose to encrypt information, and that includes the internet companies that are not even part of CALEA. That was a conscious choice that Congress made. It was a hard fought for compromise among a number of different competing interests that included the interests of law enforcement, that included the interests of privacy and civil liberties advocates, that included the interests of information security experts. And where they came out was to say, we do need to protect the right to encrypt, and we need to make sure that we allow the internet sector to build out as it will. So it was Congress's choice that Darren has said that he respects above all else, to make sure that the companies such as Apple and such as WhatsApp do exactly what they have been doing, which is to provide the best security that they can figure out how for their many millions of users in the US and billions outside of the United States. That's something that the Blackburn Cotton Graham bill is trying to change. So far, that has not seemed to be particularly popular in the public or within the halls of Congress. And I think that may be for a good reason, because Congress didn't make a mistake in 1996 by including those protections. And as I said at the outset, they've never been more important than they are today. I'm just a little shy of 2 minutes, so I will turn it back over.
So let me go first. I was there for Kalia and helped to participate in some of those negotiations, and it was perfectly clear at the time that what the FBI was saying is, I have a crisis now on digital communications, and I think the crisis over encryption can wait for another day. And that's all that was. That was not some grand solution that this solves the problem forever. And by and large, they were right. For 15 or 20 years, encryption was theoretically possible. Bad guys could put it in their computers. People who had child sexual abuse material actually did use it a lot, but mostly people didn't use it for communications. And the reason they didn't is not that it didn't exist, that they couldn't have rolled their own, but most people aren't very good at that. This became a serious problem for law enforcement when big competent companies like WhatsApp and Apple decided to throw engineers at the problem and make sure that they had treated the FBI as an adversary in their design of their systems. And that's what created the problem, and that's probably what we should be regulating. The LEED Act is, by and large, it's what law enforcement wants, and they have made it clear, if you're small enough, we're not going to ask you to design this in until we discover a problem. If you have less than 1 million devices sold a year, less than 1 gigabyte of storage, we're not going to ask you unless we see a real problem. And I think that is a responsible regulatory approach. There are people who've said, well, doesn't this mean that US products won't be bought? But the answer is, anybody who sells in the United States is subject to this regulation and can be reached with the regulatory jurisdiction of the United States. It doesn't matter whether it's Telegram or Apple that is providing the encryption. All of them are going to be regulated, and none of them are going to be regulated outside the United States, except insofar as the governments of those countries decide on their own that they want to impose that limitation. So it seems to me that, in fact, we can make this work, and we can make it work without an enormous burden on either small producers or really on the ability of US companies to sell their products abroad.
Okay, and last is, I guess, Susan. No, wait a minute. Darren, you haven't had a chance to go. Yeah, sorry. Apologies.
So are we flip-flopping? Is Susan going next, or am I going?
No, Susan's going last. You're going. It's your turn, Darren. Sorry about that.
Okay. Well, I'll be really brief here. Look, the mission in the FBI, I've got to deal with this issue, with the lawful access issue. But I've also got to deal with the cybersecurity issue, okay? So if I thought for a second that what I was doing or trying to accomplish in the lawful access space was going to exacerbate in some way or some unreasonable trade-off, that would just be ridiculous to go down that road. It's quite the reverse. This is something that law enforcement, this is a fundamental issue that law enforcement is struggling with today. And part of what is really giving me pause here is, what's next? We have no idea. Technology is moving so quick. What's the next thing? And the next industry that gets to say, you know what? We're going to choose to opt out. And what occurs to me is, look, we have a system of core values in the United States, and they stem from the Constitution, our founding fathers, and those founding documents. And those core values go all the way back. And it occurs to me in absolutely no uncertain terms that we are letting technology dictate our core values here, as opposed to letting core values inform how this technology is being applied. For folks to be able to just apply this technology and say, those values no longer apply to me, regardless of your size. That's not how we do it in this country. And it will not work. It just can't work that way. And I also want to say thanks. Hey, there's 150 people on here. There's at least 150 people who don't have their minds made up yet. So thanks for investing in the time, regardless of which way you think on this. That's what you need to be doing as citizens, is informing yourself. So thank you.
Okay, Susan.
Sure. Thank you. So, Kalia, waiting for another day? No. FBI Director Free in 1994 said to Congress, we're not going to ask for anything more. FBI was back very quickly asking for more. So I don't see it not moving in that direction. I get the pain point. It's hard when you've got a conversation wiretapped and you can't listen to it and there's evidence there and you know it. I get that. But if you're addressing issues from the law enforcement perspective, you've got to look at the security aspect and securing people's communications. And that's absolutely crucial. And that's why the point of view taken by ex-NSA, senior NSA, senior GCHQ, and so on. They get it. They get who is attacking, as in trying to do espionage. So why are the companies doing it? It's not just a whim. The reason Apple went to protecting the phones is that people in China. So first of all, when phones first appeared, it was a really expensive thing that somebody could grab just before the subway door closed. So someone was reading using their phone, reading something on their phone, and then some bad guy, some kid would grab the phone and dart out of the subway car. So what did Apple do? It put on Find My iPhone. Android did the same thing. But then that protection wasn't sufficient. And so they went to protecting the data on the phone. Why did they go to protecting the data on the phone? Because thieves in China were figuring out how to do identity theft based on the data on the phone. They did it for security purposes. So it's security, it's national security. This is about protecting our core values and about protecting our security. Thank you.
Okay, that's it. I will exercise the privilege of the moderator to say thank you to everybody. It was a very good discussion. I've been involved in this issue since the mid-90s. I actually learned something from each of you. So thank you. Appreciate it very much.